No, we'll first hear Mr. Sai Deepak. He's got an order which has been given to us. Yes, Mr. Sai Deepak. Can you just formulate what will be your line of...
with my Lord's permission, given that I have only 20 minutes, and which I expect may not even happen, I'll do my best to simply formulate my position. And as opposed to reading out from anything, kindly allow me to just engage in the bench, because my written submissions capture my position that's already been shared. So there are two aspects.
Just give us 1 second. We'll just go to your written submission. So as we are arguing, we can also keep a track of your submission.
If I may, Milords, an additional written submission.
Additional submissions or the original one?
The original. The additional is a one-page note, and I'll anyway address it. So my Lords could perhaps refer to the first written submission.
So what is broadly the line of...
Milords, if I may say so. The first law of thermodynamics effectively encapsulates the entire position when it comes to physics, and from there corollaries flow. So the central position that is effectively placed before my Lords is with respect to the distinction between fetters and powers, which is to say whether this particular area which the petitioners seek to espouse before my Lords is an area which falls within either prohibited areas, or is it something that falls within the area for my Lord's adjudication. That is the central issue. And I think that is the forest that is thought to be presented before my Lords. I am here to perhaps unpack a few leaves for my Lord's consideration. The question of legislative competence is just one aspect of the issue which hinges on separation of powers. But I go a step further, which is to say that when the petitions raise the question of change in heteronormative attitudes, does the society have a right of agency to participate in these proceedings or not, at least in this particular issue or not? Because this is not a question of separation of territories between different organs of the state, but it fundamentally hinges on the right or the agency of the society to participate in this particular discussion. And that is the central problem when these kind of issues and subjects are taken up by the court of law, as opposed to leaving it for legislative prerogative to apply its mind. Point number two, during the course of these proceedings of the last 2 weeks, quite a few times I've heard the submission being made that it's a liberal democracy, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to basically say thus far and no further? That is the central question. I represent a women's organization which equally represents the right of children, and therefore, as a civil society organization, the question that is being raised is that the nature of the prayers raised in the petition has the consequence of individualizing a socio-centric institution such as marriage, which is to say, as long as it is a transaction that takes place between two individuals who are consenting and who are not prohibited by any prohibition of degrees, so to speak, the rest of the society has absolutely no say as far as this institution is concerned. This, I'm sorry to say, fundamentally demeans the institution of marriage and takes away its social character. So these are the meta questions that I think